Hey everyone. Um, as most of you know, I'm Jayme Tenneson. I am the attorney for the NDTOA. I've been having some questions about open records and open meetings lately. I was looking for some things to speak with you about at the last meeting, and I thought this probably would be a good one. I know that we talk about it quite a bit, but it is quite important. Um, a lot of these questions have happened because of new zoning. And it seems like there probably will be more contested open meetings and more open records requests in the future. So I want to make sure that we touch the important points to make sure that everybody knows what's going on and we keep everybody in the good graces of the state of North Dakota and the Attorney General's office. So I'll share my screen here and we can go through the PowerPoint here. Is everyone able to see my screen that I'm sharing?
I've got it.
Got it.
I see it.
All right. So the first thing I want to talk about is, of course, my disclaimer. You see this from all attorneys. This presentation is not intended as legal advice. It's simply comments and materials for educational purposes. If you do have any questions or are looking for legal advice, you will need to consult with your own entity's attorney. So presentation goals tonight, I'd like to just make sure that we identify definitions applicable to open records and meetings, explain proper protocol for responding to open records requests, tell you how to properly post your meeting notices, explain quorums and what constitutes a meeting, how to enter an executive session, and to review some opinion process and potential penalties for open records and meeting violations. So first of all, what governs open meetings and open records rules? If you guys hop into the Century Codes in Chapter 4404, if you have questions, that will give you some pretty good directions or good direction of where you need to go, or what you need to do. That'll talk about both open records and open meetings, explains the executive session portion of meetings, quorums, that sort of thing, what you need to do to respond to open records. It is also governed by the Constitution of North Dakota, Article 11, North Dakota Attorney General opinions, and there's some North Dakota Supreme Court cases out there. So first of all, we'll talk about open records. What is subject to open records? So all the records that are in your possession of you as a public entity regarding your public business, that's an open record, or that's a record. So public business, it's defined as all matters that relate or may foreseeably relate in any way to the performance of the public entity's governmental functions. So that may be your budget. That may be emails between township members. That may be notes that you took at the meeting or minutes to your meetings. It may be your bidding process that you have followed, or it might be the draft of your comprehensive plan or the draft of your zoning ordinances. The biggest thing is there isn't a specific type of record that is a record. And what I mean by that is your text messages could be a record for the township. Emails, notes that you have taken, they're pretty much anything that's been recorded in the role of your duties as your township officer. So we'll talk a little bit about exempt versus confidential records. Exempt records may be released by your board if you want to. You have the discretion whether you release those records, but there needs to be an action of your board that you're going to release them. So someone that's on your township board can't just say, yes, I'm going to release that. The township actually has to make an action and make a motion and vote on that. Some exempt records are the employee's date of birth. If you have an employee's, their address, if they've taken leave, and the reasons, their driver's license, image, payroll deductions, employee applications, any current litigation records. Confidential records, they can't be released by any action of the board. And release of confidential records are actually punishable by a Class C felony. So confidential records would include someone's social security numbers, usernames and passwords, whether an employee has used the employee assistance program, and we're kind of looking more so at state government roles or county roles, and also criminal history reports, such as a background check completed by the North Dakota BCI. One thing that I actually myself got in a little bit of an argument with, or a little bit of a match with, was with draft audit. Draft audits are actually statutorily confidential. I don't agree with the law, but draft audits are statutorily confidential, so they can't be shared. I actually got a nasty letter at one point in Griggs County from the Attorney General's office because we did share a draft audit. And they weren't terribly pleased with us for that. I apologize here. So who has the right to the public record? And we've talked about this before, but every person has the right to inspect or make a request for public records. That person doesn't need to be a citizen of the township, the county, or even the state. Anyone can contact you and has the right to inspect or make the request for a public record. Generally, if someone makes the request, they can simply make a phone call or a text message or an email. Generally, you can't make them fill out a form. One of the things that I typically practice in, I guess, if I do receive an open records request in Griggs County, I do ask them to make a request in writing so they can clarify what they're looking for, so I know exactly what they're looking for. And I'm not out on some witch hunt looking for something that they didn't mean to ask for. And that can be done for a complex or request or something where they've asked for a number of different items. There is an exception if you do need to verify identity to release an otherwise confidential or exempt record. Also, if someone that is anonymous from an anonymous email address or anonymous text message, they don't have to give their name or the reason for the request. So you may at some point receive an email from someone that it just says John Doe, and the email address is North Dakota Townships at Gmail, and they still are entitled to receive open records and have their request completed. Now, if you multiple requests from that same person for the same record, you actually only have to provide one copy of the record one time. So I know responding to an open records request is kind of a big and scary thing. It really shouldn't be, and it isn't. And a few of things that people don't realize, and I think one of the things that really scares people, is you don't have to provide information that you don't have. You don't have to, if someone's asking for an Excel worksheet of your budget and you just do it on paper, you don't have to provide an Excel worksheet. You can provide what you have, but you don't have to put things in the format that they're requesting. Um, and probably the biggest thing is if you don't have the record, you don't have to provide it. You don't have to make it up. You don't have to make records. Simply, if you don't have the record, then you just let them know that you don't have it. With that said, like the slide says, you can't
Oh,
have someone that's a custodian of your records and say that you don't have them because you don't have the records in your possession. That won't pass any muster from the Attorney General's office or from the court. But if you genuinely don't have the record, absolutely you don't have to give them anything because you don't have it. So there are a couple of exceptions for not creating new records or putting it into a new format. And if someone requests that a digital copy be placed into a paper copy, then you must comply. However, you still have the ability to charge in accordance with section 440418. So you don't have to provide free copies. That's something I'll cover in a few minutes, but you don't have this isn't a free process for everybody. Also for text messages, you can provide screenshots. You don't have to provide access to the phone, or the iPad if there's messages on an iPad, but you do have to provide the messages, but you can take a screenshot of them, or print them out some other way. So if you do deny, um, uh, I guess the open records, you do have to give the legal reason, and there are several different legal reasons, such as them being exempt or confidential, or maybe just if the record doesn't exist. Don't just not answer. That's when you'll find yourself in trouble. Um, give them some sort of answer, whether it's the legal reason or that you simply don't have that record, but make sure that you give the requester a reason. Um, there may be confidential information open within documents that are subject to open records, such as if they're asking for payroll or an employee listing, that payroll might have employees' social security numbers in there, or the employee list may have social security numbers in there. So you may have to do some redacting. So you just can't just hand over a bunch of documents. You actually have to read through them and make sure that you're not giving out confidential information. I think one of the things that I've noticed in speaking with the Attorney General's office is that communication with the requester is big. Let them know it's if it's going to take 2 weeks or 30 days to get the information. Also give them an estimate of what the costs are going to be. And as long as you're communicating with the requester, you're not ignoring that request. But it might take you some time to put it together. And I know everybody is busy here. And there's farmers and people that have jobs in town, and you know that you don't have to drop everything. It's it's a reasonable time. So if it takes you a couple weeks and you work at it an hour a night or whatever to put things together, that's reasonable. And the Attorney General's office isn't going to say anything. Also, if you have a website, if the record is on your website, you can just refer them to the website, and you may not have to provide them any other records. If they don't have internet access, of course, you still have to provide them a paper copy. So here's what I was talking about charges for open records. When you provide open records, you can charge up to 25 cents per paper size or per paper copy, of a size no more than 8 by 14. If they ask for digital copies, you can't charge that 25 cents. But you still can charge for your time. So you also can charge for the actual cost of postage if you have to send those records off, or the actual cost of maps or color photos. So when someone makes an open records request, they have a free hour. So their first free hour or the first hour is free if you are required to do research, to put those records together, or to even find them. After that, you can statutorily, the law allows for you to charge $25 an hour. Also redacting the confidential information. The first hour is free, and thereafter it's $25 an hour again. You can require payment before locating, redacting, and going through the work and mailing a copy. And I actually in Griggs County, I guess I encourage that. That way you know that you're just not on a wild goose chase. If someone has stake in the game, if they've paid uh for your estimate, then I think at least you're gonna act that work is actually gonna show some fruition, I guess. Um I don't think that I would go and do any open records requests unless it's just a quick one without doing an estimate and requiring some sort of payment up front. And if they overpay, that's not a big deal. You can just refund them the money. Or if your estimate was lower, you can request that they pay everything when you're done before you provide them the information. If you get 5 or more requests from the same requester within 7 days, you may treat that as one request. So they only get that 1 hour. They don't get an hour for each of those 5 requests. And finally, access should be free. And what I talk about with that is if someone just wants to come in and take a look at say they want to come and take a look at your meeting book or your minutes book, I should say, that's free. They can just come and take a look at that. Now, if they want copies of it, you can charge for it. But access to the documents, that should always be free. We talked about a little bit about this already. How long do I have to respond? The Attorney General has kind of adopted the reasonable time standard. There's of course several factors that the Attorney General's office would determine appropriate time. One would be your need to consult with an attorney. And the other one would be redacting confidential information. If it's a large request and a large volume of documents, you would have to review all those documents. So it would take some time. The accessibility of the documents, whether you have staff or you're doing it yourself, your workload and your balancing of other responsibilities. Like I said, if there's a delay in responding, just make sure that you communicate that to the requester. That's probably, if there is some problem with your timeline, that's probably going to keep you in the good graces of the Attorney General's office. If you make sure that you can show that you made some attempts to communicate with the requester what you were doing and why it was taking some time to get it. Now we'll move into meetings. First of all, what is a meeting? And I think everybody knows this. Meeting is a quorum of the governing body of a public entity discussing public business. That's an open meeting. That's defined under section 4404, 17.1 of the Century Code. And a quorum, of course, is 1/2 or more of the members of the governing body. And that's what's required to transact business. So there are some exceptions to open meetings, and we'll talk about those right away. First, chance or social gatherings where no public business is considered or discussed. So if Larry and I are in the same township, and I run into Larry in the post office and say, "Hey, Larry, how's your crop looking?" "Good, Jayme." That's not any public business has been considered or discussed. So that would be an exception to the open meetings. Or if I went out for supper one night and ran into Larry and we had the same kind of discussion, that's again, no business was considered or discussed. Where you might run into problems is if I ran into Larry in the post office and we started talking about what we should do to the roads and what roads we should gravel, that would be a problem. The next exception would be emergency operations during a disaster or emergency declared under 371710 or equivalent ordinance if a quorum of the members of the governing body are present but are not discussing public business as a full governing body or a task force or working group. Attendance at meetings of national, regional, or state associations. So our conference in December, that would be exempt from open meetings. Training seminars where no public business is discussed. So if three guys from the same township went to a commercial applicators licensing, they would be okay. So this is probably something that I see as one of the bigger violations is committee business. Committee is two or more people acting collectively to authority delegated to that group of the governing body. It includes delegation of any public business, including information gathering. So if two or more people, this is probably more so applicable with a 5-person board or 5-person commission, but if two or more people are assigned by the board to do job interviews, or to gather information about a bridge or road, those actually need to have an agenda. They need to be recorded and they need to have minutes to them because they actually are a meeting and there is a quorum of the governing body. So if you have power delegated to yourself from the governing body, you probably should look at it as an open meeting and have minutes and notice the meeting. So regular meetings versus special meetings. Regular meetings, they're set in December of the previous year. They're quarterly, monthly, whatever you guys decide to do. Most people, I think, have them monthly and cancel them if they don't need to have a meeting. So there must be an agenda for each meeting. At a regular meeting, you may discuss items not on the agenda at the meeting. You just have to make sure that at the beginning of the meeting you put it on the agenda. And the agenda should contain all topics known at the time that the agenda is drafted. And it may have some boilerplate or catch-all items such as committee reports or attorney report or president report or road committee report, whatever. Those might be boilerplate and they might come up in every meeting. So special meetings are a little different than a regular meeting. When you create the agenda, you can only discuss the items that are on the published agenda, and the agenda must be specific. You can't have a catch-all entry such as old business or we typically have a topic of new courthouse, old courthouse in Griggs County. You can't have that. You must be specific to what you want to talk about. The reason being is that sometimes people don't see the notices for special meetings, and you don't want to try to sneak things by any of your citizens. One of the things that I try to impress upon everybody is that I encourage transparency, and I think that we owe that to the citizens is to be as transparent as possible. So we've talked about this too. Public comment policy we've talked about in the past. Public comment policy was from the 2025 legislative session, Senate Bill 2180. And it's under 4404 20.1 of the North Dakota Century Code. Each entity shall develop a policy regarding public comment, and the policy may provide that a public comment must be pertinent to the entity, may not interfere with the orderly conduct of the regular meeting, and may not be defamatory or abusive, harassing. We do have a sample public comment policy that is on the website. It actually was the legislator required that this was adopted by August of last year. So if your township has not adopted a public comment policy, you should do so at your next meeting. What it is just to make sure that people that want to speak have the ability to speak, and you still can control the meeting. So I think our public comment policy for NDTOA, you have to sign up prior to the meeting. You can only talk about things that were on last meeting's agenda or the current agenda. You have to limit your comment to 3 minutes, and the whole public comment time is, I believe, 30 minutes. So you have control of the meeting. You allow people to talk and get whatever is bothering them off their chest. But you are able to control the meeting yet. So, like I said, if you haven't done that yet, try to do so as soon as you can, as soon as your next meeting. So, notice of meeting. Again, I think this is probably something that as townships we're lacking in. The notice of the meeting should be recorded or should be given to the county auditor for every meeting that you have. The meeting notice must include the time, date, and location of the meeting, topics to be discussed, and notice of any executive session. If a meeting is held electronically, you must have the Zoom information and the Teams link in the notice. And the public should be able to read the notice and have a reasonably good idea of what's going to be discussed at the meeting. So the notice also needs to be posted at the same time that the township officers are notified of the meeting. So you may call a meeting or you might call a special meeting and you may not know exactly what's going to be on the agenda, but as soon as you solidify that agenda and know what's going to be on the agenda, you should post that at the required locations. And for townships would be the place that you normally post your notice for your meeting and with the county auditor. So if you typically post your notice of meetings at the courthouse, continue doing that to make sure the auditor gets a copy of it as well. That's actually required by North Dakota law. Again, here's some more posting of meeting notices. One thing that I should remind everyone of, if there are citizens or the general public have requested that you notify them of when your meeting is, when that notice is posted, you need to also send that notice to those individuals as well. Special meetings, one other thing, notification must be given to the official newspaper. And I think probably committee meetings would probably fall under special meetings. We'll talk a little bit about executive session. Executive session, in order to go to executive session, it must be specifically authorized by law. The most common things that I see are discussing exempt or confidential records, attorney consultation if there's reasonable, if you can reasonably foresee that you might be in some litigation, or if you're trying to bring someone or some business to the community, for development, your negotiation strategy. That can also be done in executive session. So this is how you hold an executive session in a meeting. You convene your regular meeting, take care of whatever business is on the agenda prior to the executive session. You have to announce that you're at your executive set or at your regular meeting. The topics that you're going to discuss and your legal authority for calling an executive session. And that's something, the legal authority for calling an executive session is something that the Attorney General's office watches. I know this from experience. About 10 years ago in Griggs County, we called an executive session. We did everything right. There's nothing wrong with the executive session. The only thing I didn't do is give the legal authority for calling an executive session, and we made it to the front page of the Fargo Forum. You don't want to do that because everybody in the community wonders what you were doing that was sneaky or shady, and we did absolutely nothing wrong. I just missed that portion. Also in an executive session, you need to record the session on audio or video, and you have to keep that for 6 months. That should be separate from any other recording that you're making of that meeting, because the only people that have the authority to listen to that executive session are the Attorney General's office. You also need to note the time of the executive session in the minutes and who attended. and only discuss the topics that are in the posted um agenda. Now, if you make an action, you actually should not make the action in the executive session. The action should be done at the in the open meeting once you reconvene your open meeting. And that simply can be I move to move forward with the project, or I move to um hire the Vogel law firm to represent us in the lawsuit. Something as simple as that. Um, so I'll talk a little bit about violations of open records and open meetings. The Attorney General's office does answer requests for review of an open records or open meetings violation. Any person at all may request an Attorney General's opinion, and whether it's a written denial of a request for records or denial of access to a meeting, the caveat is the request actually must be made within 30 days of the records violation, or meetings without notice must be made within 90 days of the alleged violation. So if the Attorney General issues a written opinion concluding that a violation has occurred, the public entity has 7 days to correct any violation. I have seen the Attorney General's office, if there's been an open meetings violation, where there's no minutes, I've seen them require the body to put together minutes to the best of their recollection. But if there is a violation, make sure that you do whatever you need to do to remedy it, or you could face further consequences. Just really quickly, I guess there's some resources that the Attorney General has. You can just hop on the Attorney General's website. They're super helpful. I look back at them quite often. There's an open records guide, an open meetings guide. There's a template for responding to an open records request, a sample meetings notice, a notice checklist, and a sample form for closing executive session. They're there for us to use. Just a simple quick Google of North Dakota open records guide, that'll pop it up right away. But if you have questions, those are probably some pretty quick resources for you to take a look at. And that's all I've got for you today. I thank you for all for hopping on, and if you have any questions, I'll feel free to ask, and I'll try to answer whatever I can. Does anybody have any questions regarding open meetings? Sure, I can. Actually, Michelle, why don't you email me? I can email you the slideshow.
I am putting the slides on the website. Oh.
Any other open meetings or open records questions?
Okay, they're on the website under information, open meetings, and open records.
That's a good question, Grant. How many meetings should the township have per year rather than the standard meeting in March? Like I said, you can schedule a monthly meeting, and if you decide that you don't need it, you can also always cancel it. If you schedule those monthly meetings, then you can have a regular agenda and it wouldn't be a special meeting. So I guess that would be my advice for a township, is to just schedule however many meetings you feel fit. You can always cancel a meeting, or you could call a special meeting, but whatever you think you need to do to transact your business. would be the appropriate number of meetings that you need to have.
Question on that. So timing of those regular meetings to drive around, check how you need to do your roads or whatever for the year. How do you schedule that? I mean, you're not going to know that's going to happen until, after it rains and the roads are bad or something.
No, you're not. But one thing, I guess you can call a special meeting, or if you, I guess you can guess what usually, I mean, typically the frost is done or the freeze is done by the 1st of June. If you call a meeting sometime in June, you can call that as a regular meeting. But if you also need to call a special meeting, you can do that. One thing that changed statutorily, and I did have it in the slide and I didn't cover it. Township officers can act as, if you do not have an employed road crew, you can act as the road crew, take a look at the roads, and not have to call a meeting to go out and specifically look at the roads. Now, if you're going to discuss them, and decide an action, if you're going to gravel them or do some other repair, I think that you need to call a meeting and do that and be as transparent as possible. But you can, as township officers, go check out roads and not have to call a meeting or not have to have a meeting. But like I said, with that said, you still have to, if you're gonna act on something, you still have to call the meeting and make sure that you have an official action.
So is marking the road and deciding on how many loads of gravel you're going to get, is that a special meeting?
I would say if you make that decision of how many roads you're getting or how many loads of gravel you're going to get for that road, I think that you probably should have a meeting for that. What's your opinion on that, Larry?
Do you hear me now?
Yep.
Yeah.
Okay. Usually, township board meetings are not considered to be special meetings, because the township board can call a meeting from time to time. But yes, when you decide how many loads of gravel you're going to have, those should be recorded in the minutes of a meeting.
But not necessarily a special meeting where we have to put an agenda together and say, hey, we're going to mark these 12 roads or whatever like that.
Right, and you don't have to put it in the newspaper. Just send it to the county auditor.
Okay, that's what we've been doing, so that helps me.
Yeah.
So does that same rule apply then? When you're getting ready for your March meeting and your elections and stuff like that, you get together and you say, well, let's make sure the budget is prepared and we know who's going to run so we can put their names on a ballot or whatever. Is that a special meeting or is that just a normal township officer meeting?
Well, that is a meeting that is already provided for in statute, normally held a week before the annual meeting of the township. It's commonly called a caucus meeting, where you get your audit accomplished and make sure all the finances are right and determine who has to run for re-election.
Okay, so the caucus meeting, is that treated like a supervisor meeting where I have to call the county, and put it on the calendar and things like that, or is it treated like a special where I have to put it in the newspaper?
No, that is a regular meeting. You just notice the county auditor that you're having it.
Okay.
I don't think you're going to run into a whole lot of, as long as you notice it somehow, I don't think you're going to run into a lot of problems. As long as you have a notice and agenda out, I don't think you're going to hear complaints.
Good. I would like to have the meetings once a month and have a set schedule, but that's not working out. Okay. Okay. So as when the clerk has to get a hold of the chairman to sign checks and things like that, not considered a meeting?
No, it's not.
As long as there's just one supervisor. If there's two supervisors, they discuss something else, then it would have to be a meeting, correct?
Right.
But just to get the supervisors to sign checks because the clerk has prepared everything is not.
Right. The clerk isn't one of the 3 township board members.
Okay, does the same thing apply when the clerk is trying to schedule a meeting with the supervisors to go out and check the roads, let's say? I email all the supervisors. Now, in one of the meetings, they said, well, if they reply all, then it's an open record or a violation of open records or something like that.
So I think there's a little confusion on that. So reply all to say, so if you send an email out to the other 2 township supervisors, hey, let's have a meeting on July 27th. If they and this is what we're going to discuss, as long as they don't add to the discussion, they can reply all and say, yeah, that works. 9 a.m. would work. I'm available. Okay. You're not going to have a problem with that. But if someone responds and says, yeah, I see the agenda, 99th Avenue is something that's a problem. We need to work on it. I agree that we should probably put some gravel on it. When you get into a discussion of the substantive matter, that's where you're going to end up having problems with open records or open meetings.
So putting an agenda in the email is not a problem. It's when they start responding and
right
debating the subject.
I think it's appropriate to put the agenda in there. I mean, at least you have a chance to research it, not discuss it with the other board members. But I think it's awfully hard to do business if you're not prepared. And I think a person needs to be prepared for your meetings, whether it's a township or a county commission meeting. The agenda, it's appropriate for the agenda to go up beforehand, just not discuss it.
Okay. What about an opinion on scheduling the 3rd Wednesday of every month for a meeting and then canceling it 9 out of 12 months? I mean, does that...
I don't think there's anything wrong with that. I mean, if you don't have anything to discuss, you don't have anything to discuss. I really don't think that there's anything wrong with that.
So at that point, you would just call the county and say, hey, take us off the the agendas or whatever. We're not going to have that.
Yeah, meeting. Take it off the calendar, set notice out that the meeting is canceled. And yeah, I don't see anything wrong with that.
Okay. A couple other questions. When you started talking about records, and you said handwritten notes could be a record. So I take notes, I type them up, I throw the handwritten notes away. Is that wrong?
So my opinion is to be as transparent as possible. If you throw them away, if that's your standard process, there's nothing wrong with that. There's nothing wrong with throwing any record away unless you're required to keep it. Prior to receiving a request. So if you typically, say with your emails, if you typically go through your emails weekly or monthly and delete everything that you don't need to have in there, and it may include some township things, that's a fine process. That's a process you have. No one wants to sit with 10,000 emails in their inbox. So yeah, if you go delete those, you're not going to run into problems. But where you, like I said, where you will run into problems if someone makes a request and then you start deleting stuff, that's not appropriate.
Right. Yeah, that would be federal employees, not us. Whatever.
But yeah, if you take notes, I know when I first started in Griggs County, the auditor would record the commission meetings and use that recording to write the minutes, and then when she was done doing that, she would delete them. And there was nothing wrong with her doing that. I didn't agree with it, but there was nothing there was nothing wrong as far as a violation of open records or any sort of law. She just got rid of them, and that was just what she did.
So you're good as long as nobody's already requested them.
Right. Or you're not required by law to keep those documents. You know, you don't want to get rid of your audits, I don't think. You don't want to get rid of your budgets. But yeah, if you have notes and you're going through your desk drawer and cleaning out and you throw a bunch of them, that's not an issue.
Okay, I guess I ran out of questions on my notes.
Any other questions from anybody else for tonight? Larry, anything else for the meeting tonight?
That's the only thing I've got there is the why can't I get this share to work?
Says I'm viewing your screen.
So there's a couple questions that have been thrown up in the chat. Grant, can a member threaten another member with minutes that are not true with only one party looking at the minutes? Um, the minutes need to be ratified by the board to be official minutes. I suppose they could put on true things in draft minutes, but they do need to be voted on and ratified at the next meeting. Michelle, are you asking if there's more Township Tuesdays? Yeah, Michelle. I guess Larry can talk about that. We have Township Tuesdays. I think it's the second Tuesday of every month, isn't it, Larry?
Normally it's the second Tuesday. In August, I'm going to be out of town on the second Tuesday, so we'll be, I believe we'll be setting it up for the third Tuesday for August only.
So yeah, Michelle, we do it monthly. I'm actually looking for some topics that you all have some interest in, or have questions about. Um, last month we talked about zoning. I'm guessing that's going to be a topic that comes up again, but yeah, if you have suggestions for topics that you would like to hear from us on, let us know and we can put a presentation together. Anything else from anybody? Grant, that's probably something that we can talk about in the upcoming meetings.
Okay, I've added the minutes and agendas of board meetings. To find them, we go up to About Us. And down at the bottom of the sidebar is the agendas, documents, recorded meetings, minutes of meetings. And As each one is completed, you'll see the link will fill in. Oh, here's the meeting we had just on the 8th. Regular board meeting. Here's the agenda. And we also have a summary now generated by AI that listens to the meeting. And so we provide that now on the website. There's a few things that haven't been filled in yet, but it'll be worked on as the year goes on here. Any questions on any of that? Okay, you got a question about what tool do we use for to listen? The summary that I'm using here came from a device called a Pocket. It connects to my phone, but it's separate from the phone, so I can use my phone during the meeting while it's recording in this little device, and then after the meeting, it transfers the data then into my phone, and it looks kind of handy. This I've only used it one time, but it looks like it does a fairly good job. During the meetings, we now have a meeting owl. It's a device that sits in the middle of the group and watches the whole way around and listens the whole way around, and it focuses on whoever speaks. And it seems to work quite well for that purpose. So we've used it once. So, and we'll see pretty soon what the results look like. The video will also be posted on this on the website. So, any more questions on that?
Larry, I think I'm gonna sneak out of here. I deserted a hired man to get here. So, if no one else has any questions, thanks for giving us the opportunity to talk, and see everybody next month.
Okay, well, thank you for taking part here tonight, Jayme. We appreciate the help. Other than that, we have now set the convention for November 30th and December 1st at the Bismarck Hotel. At one time, it was known as the Ramkota. Of course, we had a fire at the Ramada, so their kitchen is knocked out, and we had to go and find a different place. And the Bismarck Hotel is becoming a clarion, and they have done a whole lot of work in there. A lot of work in the rooms, the dining rooms, the meeting rooms, sound systems, and most of the work is going to be finished up sometime next month in August. So it should be a lot of new facilities there, and they're anxious to have us come in and use their facilities for our convention.
Will that be an all-day Monday, all-day Tuesday type of thing, or noon Monday through Tuesday?
No, that'd be all day Monday until noon on Tuesday.
Okay.
Unless I can get enough sponsors to pay for another meal on Tuesday, then I'd gladly continue on to fill out the day on Tuesday.
Do you have enough people volunteering to speak?
Well, we have usually have training things we'd like to do. We're limited on time.
Okay.
So, any other questions out there? Oh. Well, if we don't have any more questions, we'll say thank you to you all for taking the time to join us tonight, and thanks to those that ask questions. That helps everybody when you ask a question. So last call for questions, comments. You're very welcome, Michelle. So, well, with that, I guess we'll call it an evening then. I said we'll be on most likely the third Tuesday of August. So you can look for it on the website calendar, and I'll send out a reminder again. So.
Okay, good night.
Good night, all.